Under the Equal Protection Clause of the 14th Amendment, states and local governments are prohibited from treating individuals or classes of individuals differently under similar circumstances without sufficient justification. In addition, in Hunter v. Erickson, the United States Supreme Court held that a state law violates the Equal Protection Clause when it imposes an unfair political process burden on minority interests. Roughly 13 years later, in Washington v. Seattle School District No. 1, the court revisited Hunter in a case involving a state law that terminated mandatory busing for racial integration in public schools. In 1978, Seattle School District No. 1, which we'll call the district, enacted the Seattle Plan for Desegregation of its schools. The plan utilized mandatory busing and student reassignment to achieve racial integration. Seattle residents who opposed the plan formed an organization called Citizens for Voluntary Integration Committee. The committee then drafted a statewide proposal, known as Initiative 350, to terminate the use of mandatory busing for purposes of racial integration. The initiative was used as part of the state's referendum process for a constitutional amendment. Under the initiative, school boards were prohibited from requiring any student to attend a school other than the one nearest or next nearest to the student's home, with several exceptions. The initiative was approved at the 1978 general election by a substantial margin, and Washington passed a constitutional amendment. Subsequently, the district sued the state of Washington in federal district court, arguing that the initiative violated the Equal Protection Clause of the 14th Amendment. Following trial, the court found for the district, concluding that the initiative established an impermissible racial classification in violation of Hunter because it permitted busing for non-racial reasons but forbade it for racial reasons. Washington appealed to the Ninth Circuit Court of Appeals, which affirmed. Washington then appealed to the United States Supreme Court.